Good afternoon. I would like to start by welcoming all of you and thank you for taking the time to join us today for what I hope will be a very important conversation. My colleagues and I are joining you today from the CMPA office in Ottawa, and in recognition of the land on which we sit, I would like to acknowledge that I am a settler with British, Scottish, Ukrainian, and Polish ancestry, and the CMPA offices sit on the unceded and unsurrendered territory of the Anishinaabe Algonquin Nation, whose presence here reaches back to time immemorial. I honor and pay respect to these lands and to all First Nations, Inuit, Métis people throughout Turtle Island. I would also like to acknowledge the tragic events that took place this weekend in Saskatchewan, which weighs heavily in my thoughts and I'm sure in the thoughts of many of you this morning. My heart goes out to the victims' families, the communities of James Smith, Cree Nation, and Weldon, and the entire province of Saskatchewan. Today, I am delighted to be joined by my colleagues from across the association and with a member also of our General Council. Dr. Pamela Eisener-Parsche, our Executive Director of Member Experience, Dre Lisa Honey, Obstetrician and Senior Physician Advisor on our Safe Medical Care Learning Department, and Maureen Murphy, our partner at Gowling WLG and one of CMPA's General Counsel. I know many of you have questions, and we have set aside a significant amount of time at the end of our presentation to answer your questions. To ask a question, click on the Ask a Question link at the bottom right of your screen. If you can't see this link, it's because you're on full screen mode. Exit out of full screen mode and the link will be there. We'll collect questions throughout the presentation and answer as many as we can during the Q&A session. Here you'll see an outline of the presentation we're going to give to you today. The CMPA supports a patient's right to access abortion care. And what we plan to share with you today are some of the medical legal issues arising from overturning the Roe v. Wade decision. It's hard for us to estimate how many American patients will be coming to Canada for abortion care, but we do know that this is of a concern to some of you. So we're going to share with you the efforts we have been making on this issue, as well as the assistance that is available to you and steps you can take to minimize your medical legal risk. So let me start off by explaining a bit about the CMPA's mandate. So we are a Canadian not-for-profit mutual defense organization. And as such, our mandate is to provide our members with medical legal defense in Canada. And that includes defending civil actions and criminal charges where appropriate for patient care issues arising from the practice of medicine in Canada. We also have a responsibility to contribute to the safe medical care in Canada, and this includes identifying medical legal risk to our members and ensuring they have the knowledge to decrease their risk and enhance patient safety. So currently, CMPA member fees support assistance in each province and territory. The CMPA is structured to provide medical legal protection to physicians licensed in Canada, providing care in Canada to residents of Canada. Providing medical legal support in the U.S. is outside of our mandate. Membership fees are established on the basis of knowing that we will be exercising our mandate within Canada, and CMPA actuarial principles are based upon providing service in Canada to members with legal matters in Canada. And this includes structures to support members in all provinces and territories across the country. CMPA is set up to work within various medical, regulatory, and health systems in each province and territory across the nation. And while abortion has been banned in a number of states, there are still states where abortion is legal. This may decrease any meaningful surge of abortion seekers into Canada, especially in light of financial and border control restraints. This map is from the Centre of Reproductive Rights, and what it showcases is the current access to abortion services within each state. And one thing this map doesn't show you is the dynamic nature of the situation. In fact, we accessed this map earlier this week, and when we looked at it again 4 days later, legislation had changed in 3 states. And this is increased by the complexity given that the definition of abortion varies by state as well. So on the legend, you'll see at the top in blue where there is expanded access to abortion. This means that the right of abortion is protected by state statutes or state constitutions, and other laws and policies have created additional access to abortion care. And then you'll notice the yellow protected, orange not protected, red hostile, all the way through to the maroon illegal, where abortion is banned entirely, and the bans are enforced through criminal penalties. Today, so far, the CMPA has been intentionally focused on Canada. We do not have any plans to become an international or U.S. medical legal provider. And right now, assisting in the U.S. is outside our mandate and would be unsustainably complex, given that each state has its own civil and criminal law systems, as well as distinct legislation and regulations. So this also could mean that legal fees would be expected to be higher, damages and patient compensation could be considerably higher in the U.S., and many U.S. states actually do not have caps on damages. Punitive damages are more common, and the CMPA has no financial limits on damages paid to patients. This leads us to the potential for multi-million-dollar awards. And the changes of us extending assistance outside the U.S. would impact a small number of our overall 105,000 members. However, the costs would affect all members of the CMPA. The potential from civil suits from non-patients is also a concern, for example, anti-abortion lobby groups, which extends the complexity and implications of this issue. I'm now going to hand the mic over to Pam to discuss CMPA's assistance in this issue. Pam.
Thanks, Lisa. The CMPA's principles of assistance describe the nature of assistance that's available to our members and the circumstances under which members might be eligible for assistance. These principles provide guidance on assistance and some common practice arrangements and activities in which members might be involved. The association's current principles are designed to strike a balance. In terms of treating patients who are not residents of Canada, the principles recognize the realities of a physician's practice and their ethical obligation to see patients in urgent and emergent circumstances where care was not solicited. At the same time, those principles recognize our obligation to be stewards of the association's assets and to ensure we can be there for members facing litigation and other medical legal issues in Canada. The principles of assistance that pertain to this issue of providing abortion care to patients from the U.S. are detailed on our website. The link is shown on this slide. I'm not going to walk you through this whole graphic. It's available to you on the website in that article, Principles of Assistance. But there were a few highlights I want to share with you. In particular, when a U.S. patient is seeking an abortion in Canada, our non-resident principles apply. And what's important to clarify is what we mean by resident and a non-resident. So for the purposes of our principles, an individual who lives full-time in Canada is generally considered a resident of Canada. And that means that provision of care to that individual would be viewed as eligible for the assistance of the association. An example of that would be a student attending university for full-time studies in Canada. And in that case, you can provide care knowing that care will be eligible for our assistance. A non-resident is someone who ordinarily resides outside of Canada. Examples would be individuals who come to Canada for a vacation or for temporary work. There's more information on the website under the Principles of Assistance at that link. But there's also information in our article entitled Answering Your Questions, Providing Abortion Services to Non-Residents. That's also on our website. In the next few slides, we'll focus on the assistance members are eligible to receive when care is provided to non-residents. The CMPA, as Lisa said, is structured to provide medical legal assistance in Canada to members practicing in Canada for care they provide in Canada. When members provide abortion services to a non-resident in Canada and the action is brought in Canada, the association will generally assist the member with that action. So in the case of a lawsuit brought in Canada, the CMPA will generally provide a legal defense and pay compensation to the patients on behalf of members for injury as a result of proven medical negligence or fault in Quebec. If there are other actions, such as a college complaint in Canada, again, the CMPA will generally be able to provide assistance, including legal representation where that's indicated. However, when the action is brought in the U.S. or in another country, we will generally not extend assistance. That includes matters brought before the courts or licensing bodies, i.e. the colleges or other tribunals in the U.S. or in another country. However, we do recognize physicians' ethical obligations, and will generally extend assistance to members who treat non-resident patients in emergent or urgent circumstances, provided that the care was provided in Canada, the member made reasonable efforts to obtain an executed governing law and jurisdiction agreement, in other words, to have that form signed, which is available on our website, that the non-resident patient came to Canada for reasons other than to obtain medical care and unexpectedly developed medical problems. And so a U.S. patient in Canada arrives and requests abortion services from you. What do we consider to be urgent and emergent in this context? That will be an important determinant with respect to our assistance. So I'll turn to Lisa to assist us in answering that question.
Thanks, Pam. So there are some examples that are related to abortion of urgent and emergent care, and by no means are these meant to be exhaustive. Keep in mind that as physicians, we use our clinical judgment in order to determine if a patient is capable or healthy enough to return to their home country for care, or if they need to be seen urgently in Canada. So urgent or emergent care in first and second trimester pregnancies can be related to ectopic pregnancies, complications of pregnancy loss, so things like fetal demise, retained products of conception, and inevitable abortion, so massive hemorrhage, whether or not there's a fetal heartbeat. You also need to look at maternal conditions that may cause deterioration, so severe second trimester preeclampsia, sepsis, or massive blood loss. And finally, things like managing the sequelae of attempted self-induced abortions. So I'm going to hand the mic over to Maureen Murphy to talk to us about potential medical legal risks and some of the mitigating strategies.
Thanks, Lisa. Canadian physicians who provide care to U.S. patients are always at an increased risk of a legal proceeding happening in the U.S. But when we're talking about abortion care, the situation is a little bit unique. Many of you will be aware that, and we've talked about already, the dynamic nature of the changing laws in the United States. Some of those laws are creating the ability for people to bring a civil action against anyone who helps a patient to obtain abortion care. There's also the potential for providers to be subject to criminal action for assisting in the delivery of an abortion. And we don't really know, but it's possible that courts in the U.S. could take jurisdiction even where cases are brought against individuals outside of the state. This is what is unique. This kind of very proactive approach to litigation could create difficulties for a physician providing care to an American patient in Canada. I'm not a U.S. lawyer. I'm not trained in U.S. law, but I have been following these statutes, and they're evolving regularly. And so it's difficult to anticipate at this stage what the medical legal implications are going to be in the short term as well as the long term. One of the issues that comes up when we talk about legal risks for physician is the possibility of criminal charges being brought in the U.S. against a Canadian physician, and the possibility of the Canadian physician being extradited, so made to go back to the United States to face those charges. A Canadian doctor who was facing criminal charges in the United States would of course have the option of going to the U.S. to defend themselves against those charges voluntarily. Alternatively, the United States could seek to extradite that defendant. There are challenges associated with extradition to the United States. Firstly, typically in order to be extradited, the crime or the alleged crime that the defendant is facing must be a crime in both countries, the country in which the defendant is residing, as well as the country seeking to prosecute that individual. In the case of abortion care, abortion is not a crime in Canada, so that would make it difficult for a U.S. Secretary of State to extradite a Canadian resident to the United States to face that kind of charge. In addition, extradition is something that happens state to state. So the U.S. Secretary of State would need to bring those proceedings and engage the government of Canada on that extradition. Our sense right now is that in a Democratic White House, it's unlikely that a U.S. Secretary of State would seek to bring extradition proceedings against a Canadian resident. As I outlined at the outset, there's a lot unknown. It's murky. The law is murky in this area. And we hope the risks of Canadian physician facing charges relating to abortion care are quite low, but we'll have to see how things evolve. I'll turn it back to you, Lisa, to speak to how to mitigate the risks of facing legal complications.
Thanks, Maureen. I know that this is a lot to take in, but when you think about it, there are some things that we can do clinically to help minimize our medical legal risk when we're caring for non-residents of Canada. And the first thing that Pam has already talked about is making every reasonable effort that you can to have that patient sign the governing law and jurisdiction agreement form before you start their care. That form can be found on the website as a fillable PDF. We used to print it out and keep blank copies in our call room at the hospital. It's handy to have. And what that means for the patient is that they're just signing that if they do initiate a medical legal action, that is brought forth in Canada. So that's the first thing you can do. Another thing to think about is refraining from signing or co-signing any prescriptions via telehealth or virtual care or internet cross-border prescriptions. And this is a significant medical legal risk. And if you have no prior patient-physician relationship, the territorial and provincial medical regulatory authorities deem this as unprofessional behavior, and the CMPA will generally not be available for assistance in these situations.
Thanks, Lisa. So I think what we've managed to convey to you so far is the complexity of this issue, and this issue is larger than what the CMPA can address on its own. We have engaged in some significant communications to our membership as soon as we learned of the overturning of Roe versus Wade. We sent an e-blast to our membership, statements on Twitter, on our website, and we've responded to several direct member emails. But I also wanted to share with you what we've been doing on the advocacy front. We've been actively engaged in conversations to promote cooperation amongst the federal, provincial, and territorial governments to ensure that there are liability protections for Canadian physicians experiencing medical legal issues in the U.S. In July, I sent a letter to the federal ministries of health, families, children, and social development, as well as all the provincial ministries of health, and I also engaged with the medical regulatory authorities, the Society for Obstetricians and Gynecologists of Canada, the Canadian Medical Association, the Federation for Medical Women of Canada, and the Canadian Nurses Protective Society. Our engagement is gaining traction. The Assistant Deputy Minister for Strategic Policy at Health Canada reached out to me, and we recently had a conversation to discuss this issue. We've also spoken to the Executive Director of the Canadian Health Act and a representative of the Department of Justice about the need for cooperation at the federal, provincial, and territorial level to protect Canadian physicians in this issue. Further to these engagements, we've also participated recently in a risk forum with HEROC, which is the Healthcare Insurers Reciprocal of Canada, and that was on July 14th. And that was an opportunity for us to discuss with members on that webinar the positions of HEROC and the CMPA, which are very aligned on this issue. HEROC also is not extending medical legal insurance or assistance to any of their subscribers in U.S. jurisdictions. We've also engaged with the Medical Professional Liability Association, which is an American organization of medical malpractice insurers across the U.S. and Europe, Australia, and New Zealand, as well as some Asian countries. And we've had a number of conversations with them trying to understand their position when it comes to this rapidly evolving issue. And the bottom line for MPLA is that they still see this as a risk to their members. They're more concerned about the criminal issues that are arising potentially out of this. But they've also made clear that they don't think there'll be a lot of clarity in terms of what the legislation means in each state, likely for a number of years. So with that, in conclusion, we've provided a lot of information to you today. And so if you can't take all this information in this initial sort of presentation we give you today, please go to our website. You will find that we have an information package there and some frequently asked questions to keep you informed. We are at the CMPA are going to continue to work with our stakeholders. We're going to continue to monitor what's happening in the environment, and we'll continue to advocate for support for Canadian physicians in areas which are outside of CMPA's mandate when it comes to this issue. We are committed to continue to support our members within our mission and mandate, and we're also committed to keep you informed. So I'll just open the floor now for questions. A reminder that if you'd like to ask a question, just click the Ask a Question link at the bottom right-hand corner of your screen. If you can't see this link, it might be because you're in full screen mode, so exit out of full screen mode and the link will be there. Happy to hear any questions you may have.
Hi, good afternoon, everyone. The first question relates to whether or not this is a new policy of the CMPA to not provide assistance in the United States.
Thank you. And that disembodied voice you're hearing is Dr. Todd Watkins, our Associate CEO at the CMPA, who is receiving the questions and will share them with us. So this is a question we have had from our membership. Is this a new policy? No, it is not. We have actually had our extent of assistance principles articulated for non-residents of Canada for some time. We've reassessed them, and they do apply in this issue. Even though there's some nuance and complexity, this has been established for quite a while. Pam, I don't know if you want to speak to how long we've had those extent of assistance principles for.
Those principles have been in place since the late 1990s, when many of you who were in practice then will recall receiving the governing law and jurisdiction agreement in your inboxes, one of those snail mail versions of the CMPA info bulletins. So it has been at least 22 years that that principle has been in place.
Thank you, Pam. The next question is from Dr. Doug Wilson. How does this issue differ, or is it similar to medical obstetrical tourism from a malpractice and a criminal perspective?
Thanks for that question, Dr. Wilson. I'm going to hand that one over to Maureen to speak to in terms of whether or not there's analogies. And Lisa, you may have something to comment on as well.
Sure. And the CMPA, I'll just start by saying, has principles specific to medical tourism, particularly for obstetrical patients. So I'd encourage you to take a look at the CMPA's website for information on that issue. And the difference with abortion care is that there is new legislation in the United States that's being put in place that leads to the potential that Canadian providers could face charges or civil actions, even though they're providing care in Canada. And I think that that's unique with respect to abortion care.
Lisa, did you have anything to add on that issue?
I was just going to mention that the extent of assistance principles doesn't typically cover medical tourism. If that care has been solicited and these people have come to Canada with that care in place, and it's so the assistance principles are pretty much the same as with care for U.S. citizens coming up for abortions.
Thanks, Lisa. I would also just add, Dr. Wilson, what I think is really unique about this issue is the potential for criminal charges specific to a procedure. That's not something that we have seen before, and the nature of the legislation being introduced in the U.S. is sometimes called long arm reach legislation. It truly is unprecedented in what we've seen before, and the nature of charges that could be brought against Canadian physicians offering care to American patients within the country. Pam, did you have anything to add to that?
Well, just that we also don't know how that will evolve over time. Those those long arm statutes haven't been tested. We don't know what that will look like, and so it's difficult to provide accurate guidance when those issues have not yet been tested out in court. So that we're being cautious because of that.
Great. Next question is, can you clarify why there is a risk in prescribing abortion medications to non-residents?
Thanks. That's a great question, because I think that one of the challenges of getting your arms around this issue is trying to figure out how far the scope goes. And some of the legislations do touch on medical abortion. And so, Pam, I don't know if you want to touch on that.
Yes, in many of the states that Lisa showed on that slide from the Center for Reproductive Rights where abortion is illegal, it does specify that includes the provision of anti-abortion medications, of abortion medications. So the concern is that if that individual, that patient seeks to fill that prescription, that physician who has authorized that prescription remains at risk as if they were performing a physical procedure. So the risk doesn't change. In addition, the CMPA has had in place for many years a principle of assistance with respect to cross-border prescribing, where physicians were being asked to sign prescriptions on behalf of a prescribing physician in the U.S. Because the medication was more readily available in Canada or was cheaper in Canada. That is something that the regulatory authorities have frowned upon and is deemed, as Lisa said, to be unprofessional practice. It is also outside the scope of the assistance of the association. We have viewed prescribing when there is no doctor-patient relationship not to be compatible with the practice of medicine.
Great. We're receiving a lot of questions, which is great. If we sign the governing law and jurisdiction agreement, is it guaranteed that the lawsuit will be moved to Canada?
Yeah, thank you for that question. I think this is a common misconception is how watertight this document is. Maureen, do you want to speak to that?
Sure. Thanks, Lisa. The governing law and jurisdiction agreement is an effort that you're making with your patient to say, if you bring an action, please bring it in Canada. It's by no means watertight and would not prevent a patient from initiating litigation or a complaint outside of Canada. Also would not prevent any other person other than the patient from initiating litigation against a physician from outside of Canada. What we do hope, however, is that the agreement could be used as evidence in the event of an action outside of Canada to say to that court, listen, this matter is about something that happened in Canada. It rightly belongs to a court in Canada, not to a court outside of Canada. And with the hope of convincing that American court that the action shouldn't be brought in the U.S. But we haven't had a lot of experience with that agreement, and so we're not able to say with certainty how useful it would be in convincing an American court.
Great. Thanks, Maureen. There are two questions I'm going to combine by two different individuals. The first is, why was abortion care classified as elective versus non-elective? Dr. Honey spoke to that a little bit. Maybe you could provide some further clarification of that.
So elective care is, if you were to ask yourself, can I safely put this patient on a plane and have them return to their country to get the care that they need? Is it available in their country? And the answer is yes and yes. An abortion is not urgent or emergent care unless we have one of those conditions that we already talked about. And you can safely have them return to their home country, and it is available in their home country.
Thanks, Lisa. And maybe the follow-up was, will a deteriorating mental health of a pregnant patient be acceptable rationale for providing urgent care in Canada?
That's a really tricky question. And again, I suspect that is clinical judgment that needs to be applied there. And as physicians, if you feel that is becoming an urgent or emergent situation, that is your clinical judgment.
And would you go further to say, Lisa, that, for members who are contemplating some of these urgent, emergent conditions, you'll often hear from the CMPA the importance of documentation. Mm. I mean, we cannot emphasize enough the importance of documentation if this is what you're facing in terms of the conversations around the jurisdiction agreement, the conversations around the nature of the emergency, the justification for the emergency, all those pieces, I think, really need to be carefully documented. I don't know if, Pam, if that's what you wanted to weigh in with.
I was just going to weigh in that it's also a good opportunity to consult with your colleagues, to ask for a second opinion on whether or not your perception of urgent and emergent is one that is being upheld by one of your colleagues. And there's also the opportunity, of course, to call into the association to discuss the case with one of our physician advisors.
Thank you. The National Abortion Federation was approached by lawyers to defend physicians pro bono. What is the CMPA's opinion about this?
Yeah, thanks for that question. We have heard a little bit about that. We've reached out to the National Abortion Federation to learn more. We've yet to receive a lot of information, so it's hard for us to comment on what's being offered there. But I do think that there are a lot of implications that we've highlighted. And one thing I want to emphasize, and Maureen, I'll have you speak to this further, is it's not a simple matter of just obtaining one lawyer, right? We're talking about 50 different states. We're talking about civil legislation. We're talking about criminal legislation. And we're also talking about that if this was a lawsuit that resulted in damages, which are payments, the question is who is going to pay those damages and payments, because that's what the association has our actuarial calculations for, to ensure that we have enough assets to be able to pay patients in those scenarios. That's not what you would get with a pro bono lawyer. But Maureen, I don't know if you want to expand on that.
Sure, yeah. A pro bono lawyer is going to give you a legal defense in helping you to respond to any claim against you. But as Lisa indicated, they wouldn't necessarily indemnify you for any damages that a court might find are owing against you. So that's the risk that you want to contemplate instead of just relying upon the availability of a legal defense.
The next question asks, will CMPA consider such factors as a patient's ability to access another state versus Canada being more proximate in considering coverage for the Canadian physician who may be able to provide that service?
Yeah, that's an interesting question, right? About, like Lisa was saying, is the abortion care available? The other thing I'll just say is one thing that we are concerned about are the American citizens who will likely be impacted on that and their resources and ability to travel. Unfortunately, this type of legislation will most likely impact women of lower socioeconomic status. Their ability to travel may be limited. That said, when you look at the map, there are options in terms of jurisdictions to travel to. Pam, do you want to speak to if that would affect our extent of assistance principles?
That would not have an impact on our extent of assistance principles, given that abortion does remain available in several U.S. states. We've also been made aware that some U.S. states, as Lisa had said, are expanding their access and trying to find ways to assist patients in the U.S. to come to their state should they request an abortion.
And I'll just add, there's a number of organizations in the United States as well as governments trying to facilitate that access within the United States. So if you're trying to help a patient in the United States, referring them to an organization whose mission and mandate is to facilitate abortion care in the United States is an option.
Pam, there's a question regarding dual citizenship. And does that make a difference with respect to CMPA's assistance?
So that's an excellent question and a complicated question because it very much depends on many other factors. So dual citizenship alone would not qualify the care for the assistance of the association. It would really depend on, does that individual live in Canada? Does that individual have very close connections to Canada? If they have dual citizenship but haven't been to Canada in 10 years, for instance, that would be problematic. But if they spend half their time in Canada, if they have a provincial health number, for instance, those are the kinds of factors that we would need to be looking at. Did you want to add anything to that, Maureen? That's the kind of conversation you and I have.
Yeah, I think that's a pretty comprehensive list. Essentially, what the association's principles are based on. One is, as Lisa has indicated, is it reasonable to make that patient go back to Canada? And I think as a clinician, that's what you want to be asking yourself. That's why the CMPA created the principles it did, recognizing the obligations physicians have to provide urgent, emergent care and what's reasonable. And if it's not reasonable to send them outside of Canada, then the association is going to be there for you. If you are a dual citizen, but you live outside of Canada, the reason the CMPA created the principle it did is because there's a higher risk that U.S. litigation might be commenced against you because that patient lives in the United States, works in the United States. And so if they have an issue associated with the care you provide, they're more likely to initiate litigation in the United States. Whereas if they have a close connection to Canada, they've got a house here, they've got a health insurance card, or any of those other factors that Pam mentioned, they're more likely to initiate litigation in Canada, which ensures that you would be eligible for the association's assistance in Canada.
Pam, can you comment on the number of American women that you're aware of who have sought abortion care in Canada in the past and since Roe versus Wade was overturned?
So we did ask that question and obtained some data from CIHI, and it was quite a low number, in fact. It was in the ballpark of 150 per year seeking abortion from the U.S. And we have had no information about the number since Roe versus Wade was overturned. That's not something that we have had access to. We've had a few members calling us and asking us questions about our principles and what they mean. But as of yet, very few calls that are about a specific patient.
Great, thank you. Maureen, is there a risk difference between a patient living in a state where abortion is protected versus living in a state where abortion is illegal? You spoke to that. Maybe you could expand on that a bit more.
Sure, of course. So a patient living in a state where abortion is legal, there's probably no U.S. legislation that would be used to initiate proceedings against a Canadian provider, whereas a patient living in a state that has that kind of legislation does increase the risk that a patient or another person could use that legislation to initiate proceedings, or a prosecutor could initiate criminal proceedings against a Canadian provider. If you weren't clear about the risks associated and the legislation in place in the United States, you're not alone. We're all in this together. As mentioned, the legislation across the United States is varied state by state, and it's complex, and it's constantly actually being challenged in court as we speak. And so it's really difficult to give any kind of certainty with respect to the risk of litigation and how that might come to be, certainly at this early stage.
Maureen, while you have the mic, what is the likelihood of federalization of a U.S. arrest warrant?
I'm going to say I'm not sure, Todd. As I indicated, I'm not a licensed lawyer in the United States, and I think it's difficult for us to comment on that issue. And I think as we were talking in preparation for this, this is one of the challenges for the association, is that most of the lawyers that the association has relationships with, we're not U.S. lawyers. We're not trained on the U.S. law. The CMPA has lots of great knowledge about Canadian law and Canadian resources, but when it comes to U.S. law, that's not the CMPA's expertise. Thanks,
Maureen. A question regarding, can a clinic in Canada be sued if the physician provides abortion to a U.S. citizen?
I'm happy to jump in there and give the answer that we typically provide anytime we get asked, can someone be subject to litigation or can they be sued? And the answer is anyone can always be sued. It's really difficult to predict in advance how a legal action might transpire. But in the event that a patient is harmed, or in this case, in the event that somebody is concerned about the facilitation of an abortion, it's possible that anyone involved in the treatment of that patient could be named in a legal action.
And just to be clear, we provide medical legal protection for members. We don't provide medical legal protection for clinics per se. So I think that that's an important distinction. And so it also adds complexity and nuance for physicians who are working within clinics. We recognize some physicians own clinics, but I think really thinking carefully about the medical legal protection that's needed for the clinic, not just for the physicians and the other healthcare providers, would be key. I don't know, Pam, if you have anything there.
That's a really good point, and an opportunity for us to remind you to look at the extent of assistance principles for clinics. There are some clinics that are wholly physician-owned that may be eligible for the association's assistance, but there are many clinics who are structured differently who would not be eligible for the association's assistance. So it would be important for you to look at the structure of your clinic as well.
Thank you all. Next question is related to a comment about from time to time, women do not provide their address when seeking care. So if the physician is unaware of where the patient resides and provides service, what is their risk? And will the CMPA assist?
Lisa, do you want to talk about that just from a practical perspective?
Yeah, I think that if a patient doesn't have a health card, and an address is always on their health card, if there's no health card, I suspect we'd be asking where they're from, and perhaps good practice to do so, and to then, if it is an emergency, make sure that you consider or make a reasonable effort to sign your governing law and jurisdiction agreement.
Thanks, Lisa. And there's a similar question here, just for completeness. In the case of a foreign citizen that is living in Canada, what should we check or do before proceeding to make sure the person is considered to be a resident of Canada?
Is there anything additional, Maureen, you would contemplate?
I think Lisa's answer is actually quite relevant to that question as well. The association's principles are not based on citizenship, and that's important, as Pam indicated. It's more about a close connection to Canada. So we mentioned having a health card is a factor to be considered, but it's not the only factor. If you discover they don't have a health card, that's an opportunity to ask some more questions. And if they indicate to you that they don't have a health card because they are a full-time student attending university and they live otherwise outside of their university in another country, but they're living here, going to school here for the entire school year, then typically the CMPA would consider that resident not a citizen of Canada, but they would be a resident of Canada. So it's just an opportunity to ask some of those questions and determine, are they living in Canada on a full-time basis, or are there other factors that would deem them to be a resident of Canada?
Thanks, Maureen. Pam, can you comment on the number or percentage of Canadian women who have had an abortion in Canada who launched litigation against a physician?
Lisa, do you know the answer to that question? I don't think that we pulled out that analysis.
No, we don't have data specifically on that, other than I can say it's not a high number. But the other thing I would just say is I would just be cautious drawing any inferences from that historical number. The landscape has changed. We are in a different world now. So I think that irrespective of that number in the past, which all I can say is it would be infrequent, and like Pam said, 150 abortions for U.S. citizens per year. We actually don't know how many abortions are being performed in Canada per year. But moving forward, the goal of us in this presentation is just to flag your medical legal risk is different now moving forward for providing care for any U.S. citizens coming into Canada than it was previously.
Particularly in light of the legislation that allows for a suit to be brought for aiding in obtaining an abortion, which completely changes the situation from one of pure medical negligence, which it had been in the past.
Thanks, ma'am. We have a question received in French, and my colleague Chantal is going to ask the question.
If a litigation is launched against myself for having proceeded with an abortion on an American patient from a state where it has become illegal, could I risk being arrested if I cross the border to go on vacation, for example? If I understand properly, the CMPA in that context cannot protect me.
I'm sorry, but I'm going to answer in English, despite the fact that I speak French. The language of legalese is sometimes challenging for me to interpret on the fly. So the short answer is if there were charges against you, criminal charges launched against you for having provided an abortion and you attempted to cross the border in the U.S., there is some risk, and Maureen can elaborate on that, but there would be some risk that would be picked up at the border and would create challenges for you. You would also be correct in your question that is not something that the association would be able to assist with. And that's really why we're flagging this for you as a risk to you that you need to be aware of and thinking about. It's not something we would be able to assist with at the time.
Puis, nos discussions avec...
And in our discussions with the federal government, we have mentioned this question precisely. We said that if a physician is on vacation in the U.S., there is the possibility that if there are criminal charges against them, that they could get arrested. And the risk is that at CMPA, we cannot help you in that instance.
Risk of being detained at the border if there are any criminal charges arising from care for a physician who's even just going to the U.S. for a vacation, for example.
Sure, thanks. And I'm going to respond in English if that's okay as well. This is what I was talking about earlier in terms of the potential for criminal charges to be brought against you, and you would be notified if those criminal charges were brought against you, and you would have the opportunity to defend yourself. And if you're defending yourself, it's unlikely that, you know, a warrant would be out for your arrest, which would implicate you crossing the border. If you chose not to defend those charges, there is, as Pam indicated, the possibility that information about the warrant and about the charges could be shared with border services in the United States and have implications for you crossing the border if you decided not to defend yourself against those charges.
Thanks, Maureen. This isn't a question, but it's a clarification. It comes from the Executive Director of the National Abortion Federation. They would just like to provide some clarification on one of the questions that was previously asked. They say, we didn't offer to provide representation. The National Abortion Federation of Canada said during a call that that if there was a legal action against a Canadian provider, we would imagine it. Sorry, my screen flipped. Apologies. That there would be a legal action against a Canadian provider. We would imagine it would be a significant issue that would be of interest to pro-choice individual professionals. We said that we are aware of lawyers and law firms providing pro bono counsel to other pro-choice matters in Canada, and we would imagine that there would be lawyers willing to do the same. Do the same. So that was just a clarification. Question regarding, will the map of the state status be updated frequently for the participants' use?
Thanks for that question. I'm just going to mention that map is not a CMPA map. That's the Center for Reproduction Rights map, which is an American organization. So the website was provided on the slide, and we'll make sure that that's available on our website. That's not something that we will maintain or keep up to date. As we mentioned, it is changing rapidly. And even I suspect the color coding is going to become quite challenging as you know, as we have these challenges in court, and as even sort of competing or protecting legislation is being developed. Even some of those categories might be really harder to define, because I suspect there's going to be a lot more gray emerging rather than clear categorization. I don't know, Pam, if you want to comment on that.
Yeah, I was just going to highlight again something you said in your presentation, Lisa, which is that we'd accessed that map on Monday of last week. And then on Friday, when we took another look at our slides and we accessed the map again, it had changed in 4 states. So that's the challenge. So the Center for Reproductive Rights updates it on a regular basis, and that's the best source for your information that we've found.
Thank you. The next question is, does the CMPA get involved in the protection for criminal charges against physicians in other areas?
Yeah, so that's a good question. As I mentioned in my remarks, the answer is sometimes, and it really depends on the circumstances. Pam, do you want to speak to that?
So physicians in Canada who are members of the CMPA who face criminal charges related to the professional practice of medicine in Canada are eligible for our assistance. So criminal charges relating to medical care are eligible for the assistance, provided those charges are in Canada. Charges being brought in the U.S., the member would not be eligible for the association's assistance. So I think that, you know, the key message is criminal charges related to the professional practice of medicine that are in Canada are eligible.
Thanks, Pat. If the patient claims they face discrimination for being a gender minority, trans, non-binary, female, and cannot therefore reasonably access abortion care in their country of origin, will they be protected? Will physicians in Canada be protected for treatment of that patient?
I think it's another complex question, and I think too that, again, to be clear, that it's such variation state to state, and the issue is can you access care in some states? My understanding, and Maureen, you may be able to speak to this, but in some states there are really quite robust protections, in fact, for vulnerable populations, including trans patients. But I don't know if you want to speak to that.
Yeah, I think the issue whether they can obtain it anywhere in the United States, even if they can't obtain it in their state. And so you'd be having to look at whether the care that they require is available somewhere in the United States.
Thanks, Maureen. Another legal question, Maureen. So if there's a state looking to take legal action on a Canadian provider, can the Canadian government, either federally or provincially, agree not to cooperate and refuse to provide medical records?
So that's a really interesting and an intricate question. In Canada, we have very robust privacy legislation. So typically any request for medical records that would come to a Canadian provider, the Canadian provider, whether it's a hospital or a physician or a clinic, would need to first consider if they have the patient's consent to release those records. And without the consent of the patient, at law, they would have the ability to refuse a request for access to those records. So I think at the start, it's primarily about anyone who receives that request in Canada attempting to get consent of the patient, and the patient has the ability to say yes or no to accessing those records. If the patient says no, and the individual from the United States is still seeking access, then you're right, they would need to initiate some kind of likely a court proceeding in Canada to compel the Canadian provider to share those medical records. So it would be up to a court in Canada to compel the production of those records if the patient doesn't consent.
Thanks, Marty. Pam, there's a question here, a practical question regarding if a physician has a patient in a clinic waiting and they're looking to seek assistance from the CMPA or advice from the CMPA from a physician advisor. Sometimes it takes a few hours or a day to actually get that service. Can you provide some advice on how to access that support quickly?
Thank you so much for an excellent question. And I think it highlights the need for us to be triaging calls when they come in. So if you have an urgent situation like that where you need assistance in that very moment, we do have a process. If you say that to the member service representative on the phone that there is an urgent need for a very quick answer, we mobilize our resources to get you a physician advisor as quickly as possible, which is generally within the next half hour at the most. So if you have a really urgent need, you need to let us know that and we will respond.
Thanks, Pat. Dr. Jennifer Tang asked the question, I'm curious if the long-arm legislation potentially impacts only the physician performing the abortion or whether any physician who is considered accessory would be impacted, for example, the emergency room physician who diagnoses an ectopic pregnancy or assists in the initial management or refers to an abortion clinic for care.
Thanks, Dr. Tang. Again, we're not experts in U.S. law, but my understanding, and Maureen, you can clarify this, is that some of the legislation is quite broad, particularly when it comes to criminal charges.
Yeah, some of the legislation is quite broad, but I just emphasize what we talked about earlier, that the law in this area is quite murky. It varies by state to state, and so we're not really in a position to answer with any certainty as to who might potentially be brought into that kind of action. There is the potential that anyone involved in the care could be brought in, but it's difficult to speculate in advance.
Thank you. I'm just doing a time check. We're at 1:53, so 7 minutes left in the session. There are a number of questions here, some of which, if you have asked a question, I may need some clarity on the specificity of your question, but I'll continue on with what I have. What role, if anything, does Canadian immigration play in allowing pregnant women to enter Canada for care?
Interesting. Maureen, any thoughts on that?
I'm going to say that that's something that's outside the CMPA's scope of assistance and certainly outside of our sort of usual issues that we consider. I think that if you have questions about immigration, then I would defer those questions and have you reach out directly to Immigration Canada to get answers from those experts.
Thank you, Maureen. There are a number of scenario-based questions as expected, and I would encourage physicians to call in and speak to a physician advisor for their specific detailed question and answer. There is one here, though, that related to, could you speak to the risk of failure to diagnose or treat if Americans are in Canada and are not provided with the appropriate treatment in a timely manner due to fear of litigation? For example, a Canadian physician refuses to offer further evaluation or treatment of an American patient due to liability concerns, and that patient ultimately develops a complication like a ruptured ectopic pregnancy.
So actually, this came up in the conversations I had with the MPLA, which is the organization of mostly U.S. medical malpractice insurers. Something they're quite concerned about in the U.S. And one of the principles they talked about was the ethical duty not to abandon your patient. The same applies in Canada. As much as we recognize this does create a certain amount of fear, Pam suggested some great strategies, and you've heard so far. So we've got the jurisdiction agreement, we've got the consult your colleagues, we've got the call the CMPA for support. Anything else, Pam?
No, I mean, I think it really is about ensuring that you have around you others that you can chat with about these very complex situations and getting some guidance as you move through those scenarios.
Yeah, and I just add that I think, as we mentioned, the CMPA's principles are designed to reassure you that where it's within your standard of care to provide treatment to a patient, based upon the presentation of the patient, that's where CMPA's principles are designed to assist you.
Thank you. There's a question regarding physicians who frequently travel to the U.S. or own a property in the U.S. Does that affect their liability and their ability to travel to the U.S. if they have provided abortion to non-Canadian residents?
I think, again, the answer is it depends, right? So if you've provided abortion to American patients and there's no pending charges or action, then you're fine. However, if something does arise, then there's a potential risk when you're crossing the border. And I don't know, Maureen, if there's anything else you can say on that.
Yeah, I think that's the issue, Lisa. If there's no charges against you, then there'd be no issue crossing the border. And so it's just, and even if there are charges against you, you could still potentially be able to cross the border if you've defended those charges. But it's again difficult to speculate the likelihood of charges being brought against you. We think it would be low at this point, but it's difficult to say.
The next question is related to a Canadian patient who needs to go to the United States to seek an abortion due to the gestational age being higher than what Canadian clinics can provide. Would they now be at a higher risk for being charged themselves? So it's a patient-related question.
So I'll jump in and have others join in. I think that question, if you're making a referral to another provider, typically you're going to be referring them to a state or jurisdiction where that service is legal. And if that's the case, then it seems if they're from that jurisdiction that the risk would be low. There is some risk associated with providing that kind of referral if the patient but if they're a Canadian patient, it's unlikely that any other state's jurisdiction would come into play. So again, it's just about referring them to a jurisdiction where that kind of care is considered legal.
Thanks, Maureen. I think we can consider this our last question. Again, there are other questions here that we won't get to all of them. I'd encourage our members to call in and seek assistance from the physician advisor. The last question is regarding the level of documentation required to prove the status of a patient. For example, what document would suffice for international student, proof of being an international student who is residing in Canada? Is their word sufficient, or do I need to see documentation?
Maureen, you want to take time?
Sure. I think that when the CMPA sets out its principles, again, they're deferring to the member's judgment in determining whether an individual has a close connection to Canada. And if a patient says to you, I'm a student at the University of Guelph, then you would assume, unless you have some reason to believe that they're lying to you, that's information is accurate. It's not intended to require them to provide all kinds of documentation unless there's reason to ask for that documentation. But typically, if you've got a good, trusted relationship with your patient and you believe the information that you share with them, then you would believe that information, document it, and that would be the basis for your determination that they are a resident of Canada.
I want to thank you all for joining us today. We appreciate all the questions that we've received. And again, we know this is an issue that creates a lot of concern for many of you. I want to encourage you again to go to the CMPA website. We do have an FAQ section, which we do regularly update, which will, a lot of those FAQ sections speaks to many of the questions we received today. And also, as Dr. Watkins said, if you have a specific clinical scenario that you're concerned about, please reach out and call the CMPA and speak to one of our physician advisors. We would be more than happy to offer some advice in that scenario. Thank you very much, Pam, Maureen, Lisa, and what you can't see is the whole team of individuals at CMPA supporting this production behind the scenes. Thank you, everybody, for joining us this afternoon. Do take care.